Calling 210444 GC, Macklin versus Pinewood Circle Village Apartments. Your appearances, please.
Morning, Your Honor. Sidney Katz, P51471 on behalf of Pinewood Circle.
Ma'am, your name?
Michaela Macklin.
Thank you. I thought I saw someone from the towing company. We're here this morning on an adjourned hearing on Ms. Macklin's petition regarding impoundment of motor vehicle. Mr. Katz, have you had an opportunity to speak to Ms. Macklin before?
I have not, Your Honor.
Would that be helpful this morning?
It could. Let's see what happens. Might as well try it.
Thank you. Mary Ann will move you into a breakout room in just one moment.
Miss Macklin, can you hear me?
The BOCOM video came on and went right back off. I'm not sure if they're here for this or something else.
I'm sorry, we're waiting on an attorney. We are here for something else.
What are you here for?
It's a auto
The
owners.
auto owners case?
That's correct.
We'll have you checked in. Mary Ann will move you back into the waiting room when the other party is here. We'll pull you back in.
Thank you. The attorney should be Tom Stidham. That's coming in and for JT Crova. For JT.
Thank you.
Thank you.
Mary Ann, I don't know if you saw it yesterday, but that last case at 10 o'clock, Country Metals versus Dun and Dunn, was dismissed yesterday.
I didn't see that. Thank you.
No problem.
Did you see on our docket, it has a 6 PM case?
We don't have a 6 PM case, I'm sure.
Is there something you forgot to tell me?
I don't see it. I'm happy to do nighttime court. I think some people's schedule would appreciate it, but I guess I'll have to put that on the calendar to discuss. I think with YouTube, it should be possible. People who can't come in or unable to access Zoom during the day, we could do a night, maybe once a month.
I kind of like that idea.
Guess we should float it and see what happens.
I got you on that one. You know,
I'm a fan. I do. Thank you very much. Is that funny? I know what that is. That's the case where the attorney said, we'll have it to you within the week. And I said, don't tell me it's a week because it's not going to be a week. That case where they had to agree on language. And I asked them to put it on my review docket. And I still haven't seen the settlement documents. So they'll get a notice to come back in and visit us, which usually prompts the submission of the order. I haven't seen it. We'll see what happens. What would night court look like? What would it look like? Like, what would you run at night? The same thing that we do. Maybe a nice, I don't know, 4 to 6, 5 to 7. Because you know, I know. Mr. Katz is back. Ms. Macklin is back.
We timed out, but I don't think we were going to get anywhere.
Okay.
And just as a FYI, my client couldn't make it. Her son got into a car accident and she's in the hospital or something like that. So I spoke to her yesterday briefly, but I don't know if she'll be needed or not. I think someone from the towing company is here as well. So
I don't see anyone from the towing company.
oh, I thought you had mentioned someone was.
There was a towing company, but it's for a later case. The last time we were here, Mr. Frazier from Frazier Auto came. And the issue was Ms. Macklin's claim is as to Pinewood Circle. I think the allegation is that there was an improper request for tow. So the towing company came last time, but I don't think that they were the agency that Ms. Macklin had an issue with. Am I understanding your position correctly, Ms. Macklin?
That is correct, yes.
So as for your petition regarding impoundment of motor vehicle, Macklin, you want to state your position for me, please?
Yes, as I stated in the written correspondence, the vehicles were not properly removed, and that's why I'm here. They did not follow the guidelines for a proper tow, according to the lease and according to the Michigan state law, and that's why I filed this petition, excuse me.
You have to tell me why.
Oh, okay, I'm sorry, I've never done this before.
No, that's okay.
Okay, so I have vehicles on the property. According to the lease, there's no number of vehicles that they say. I did follow all the rules of the lease, which I do have with me, which I know this is virtual, so it's kind of strange, but according to the lease, they said that the vehicle has to be registered, the vehicle has to be parked. Of course, legally, the vehicle has to be operable. All these things, I kept my vehicles registered. I drove the vehicles when I could. As I mentioned before, I worked for the post office. My post office vehicle was there due to the fact that my kids' school was virtual. The reduction of my hours was cut because my kids were doing hybrid school. So my boss at the post office told me that I could not have my vehicle there. So I had asked permission to have the vehicle there temporarily during the pandemic time by previous management, which I do have an email from them as well stating that it was okay for me to have that vehicle there. The vehicle was not driven much because it was my work vehicle. However, I did move it from my garage because I did purchase a garage to store the vehicle in. But as I stated, I have kids, their toys were in there. So I would move the vehicle out to get their toys out, put it back in, excuse me. My main concern is that they did not also give me proper notice. The vehicle was tagged at 8 o'clock in the morning. I think it was said 8:45. I have the proof of that sticker as well for both vehicles. They had the vehicles towed within an hour of putting the notice on there. On the 2 days out of the week that I work was the day that they did it. So had they had put the stickers on there Sunday through Wednesday, I would have seen it immediately and have removed the vehicles. But like I said, they never said anything to me about the vehicles. They never asked me, put in any written or verbal request to move the vehicles. If they did, I would have moved them. My aunt lives in the subdivision directly behind the apartments, and my Jeep is there now. My work vehicle is still there because the postmaster ended up giving me a vehicle for the route. So now I'm trying to sell the work vehicle because I had a personal vehicle route with the post office, and now I was given a government vehicle for that route. There was no need for them to tow, other than the fact that I think they were upset because I had chose to move and leave the property. So I really feel like maybe it was something personal because I did not renew my lease. I'm not sure. Like I said, they waited to the prime time to when I wasn't home. I was in the process of moving, so I didn't have, I needed that money for other things, and it just hurt that the complex would do this to me after I paid my rent on time for the 2.5 years I was there, made sure I took care of whatever needed to be done as far as providing proof of renter's insurance or whatever they need, I took care of it. And it is just disheartening that they would do this during a hard time, during a pandemic. I'm a single parent. I just try to work and take care of my children, and that's why I'm here. I filed the petition because it's my legal right to do so, and they were in the wrong for this.
Ms. Macklin, just so we're clear, you're saying that your lease did not have a limit on how many vehicles you could have on the premises?
Correct. It does not.
And that both of these vehicles listed, the Charger and the Cherokee, were both licensed, plated, registered, and insured, all that
Correct. Yes.
that are required? Okay. And that the first notice you received was the sticker that was on the vehicles the day it was towed?
Correct. So I never got notice. I came back home and the vehicles were gone.
How did you find your way to Fraser Towing?
I called the emergency number, and the maintenance man said, well, they may have been told, we towed through Fraser Towing. So I called Fraser Towing. Of course, I had to wait till the next day because they were closed by the time I got home from work and picking the kids up. So I had to wait till Friday, miss a day of work because I had to get them out so I wouldn't have to be hit with all those storage fees. And that's when I was notified that their enforcing deed were towed by, and Pinewoods gave them permission to tow.
Gave permission, or Pinewoods ordered the tow?
Pinewoods ordered them.
Okay.
Because like I said, the sticker on the cars were dated for November 12th at 8:45. I confirmed, and I also wrote on the receipt. Actually, I had the lady from Fraser Towing write on the receipt that the cars were received in their lot at 10 o'clock in the morning, the same day.
Anything else, Ms. Macklin?
No, that's all. Thank you.
Mr. Katz?
Your Honor, I believe Ms. Macklin was aware that there were issues prior to this. My client's not here, so I can't tell you exactly when they had discussions about this. Now, Ms. Macklin had 3 vehicles in total. Okay, she's aware of the parking situation at the property. She had a vehicle that was filled with junk in the front of the property. She was told to have moved it. She was aware that she had to move these vehicles, Your Honor, based on my discussions with my client. My client did not physically tow this. Ms. Macklin probably should include the towing company as well as my client. I mean, there is no law as far as how many hours, I don't believe, that have to be provided to Ms. Macklin. She was fully aware of that these issues, that these vehicles should not have been where they were. And she was warned that they were going to be towed. This was not the first time she was told that they were going to be towed if they weren't moved. 3 vehicles, 1 person in the property. This is not a storage facility for vehicles. And she is aware of that.
Okay, Mr. Katz, do you have any proof that she was aware that these vehicles were going to be towed? Or that there were some issues?
Again, my client's not here to testify to the fact, but based on my discussions with my client, they had notified Ms. Macklin. This was an ongoing issue. And Ms. Macklin's claim that this was because she was moving, I mean, that's somewhat ridiculous, Your Honor. If anything, my client would probably be much more willing to accept the fact that if Ms. Macklin were removing these vehicles and leaving the property if they've had the issues, then why would they want to tow it at that point? This is not an issue as far as my client retaliating against Ms. Macklin because she was moving. They have every right to move from the property if they want to. I mean, they have people moving in, moving out all the time. They're not towing vehicles from everyone who's moving out of that property. So this is not something that they did just in spite of Miss Macklin. And again, I'm not sure why the towing company is not here, but I think that this was an ongoing issue. They were fully aware of it.
I'm not sure why Fraser Towing is not here either, Mr. Katz, other than the fact that Ms. Macklin's petition is very clear and very specific to the improper tow being as a result of actions of Pinewood.
Well,
I'm
but I
not
don't
saying,
know
I'm
how-
not saying that that's not that's the reason why they're not here, but we had the conversation, or we started to have the conversation when the parties first appeared on March the 2nd, 2021. And your client was aware of what the issue is. And so if it's your position that you can't proceed this morning, that's one thing, but you're making assertions or you're repeating what you're saying your client told you, when I think that we, including your client, started discussing this petition last month. So I'm
Right,
not
I think
sure.
the issue is that they were unrepresented and you couldn't hear the case without their representation at that point, if I'm correct.
Correct,
if-
but we
if
had
we-
the conversation about the proper parties and what the issue was, because Mr. Frazier, I had not had him speak at one point and I actually read the statute allowed that she could bring her petition as to the police agency, the towing agency, or the private owner, if it was the private owner who called for the tow.
Correct. Correct.
Okay.
But I was told that Fraser was going to be here. If we need my client to testify to the fact, then we'd have to adjourn this so that they are available. And I could bring proof that they are actually, that their kid is in the hospital and that they were unable to make it here as a result of that, Your Honor.
I guess then we should have started with, Your Honor, I'm unable to proceed this morning. I'd like to request.
Well,
an
I always hope that I can resolve it without that issue. I mean, I do a lot of these cases where I usually never need my clients at court. So I figure if we don't have to adjourn, why try the chance of adjourning it, Your Honor?
Well, this is the thing, Mr. Katz, this is the second time that we've been here. We're talking about $684 that Ms. Macklin paid less than 24 hours after the vehicles were towed, and her issue is pretty clear based on the petition. And it's my hope that your client had provided you with a copy of the petition before we, before you zoomed in this morning. And that's why I wanted you to talk to Ms. Macklin before I pulled you back into the main room. I just, it sounds like this is a thing that could be resolved. She's already stated her position on the record and you've responded. And now that you've responded, you say that you might want to have your client present, or?
It becomes an issue of how much advance notice Ms. Macklin really had and how aware she was that her vehicles were going to get towed. Her claim is that my client was upset that she was moving out and that they basically, first time she's ever heard of this and first time that she thought, she got tagged. My understanding in all my discussions were that she was fully aware that this was an issue. And this wasn't something that suddenly an hour after, this happened, that suddenly her cars were gone. I mean, Miss Macklin was using this as her personal, parking lot for 2 additional vehicles. She had 3 vehicles on this property. And this is a property that she's fully aware has limited parking.
Well, Mr. Katz, if you have a document that shows that there was limited parking and that Ms. Macklin was not allowed to have 3 vehicles on the property, I'd like to see that.
Well, I think she was aware of the situation, Your Honor. That's the point. The fact is that she's claiming limited knowledge that she had about these vehicles. She was shocked that her vehicles got towed. I don't think she was so shocked. I think she was shocked by the fact that they actually followed through with what they were claiming that they were going to do, Your Honor.
Well, Mr. Katz, I'm looking at the statute, and the statute requires and actually puts the burden on the person who ordered the tow to set forth the reasonableness of requesting the tow. And so my question to you becomes, was there a limit on the number of vehicles that Ms. Macklin could have?
I don't believe that there's a limit to it. She did have to rent a garage, which she said she rented, but yet she wasn't parking her vehicle there because she parked bikes over there. So the reason for her renting a garage at the property was because there is limited parking at the property. She's fully aware of that. At the same time, like I said, based on my discussions with my client, Ms. Macklin was fully aware that these vehicles were going to get towed. As to the specific timing of when those tags were placed and when it was eventually towed, I don't have those specific times, and that's where I thought that the towing company was going to be here, so we would have that information. And maybe they're under the impression that my client's not going to be here, therefore they didn't show up. I have no idea. I was told that they were going to be here.
Mr. Katz, based on the petition that Ms. Macklin filed and the reading of the statute, which is 257.252F, it indicates that at a hearing on the petition regarding the validity of the tow, the private property owner shall have the burden of showing by a preponderance of the evidence that it has complied with the requirements of the Act in reporting or processing the abandoned vehicle or having the vehicle removed pursuant to Section 252D. And that is why I've asked, was there some limit on the number of vehicles that she could have? And the answer from both Ms. Macklin and yourself is no, but she was aware that there was some parking situation. But if there were no limit on the number of vehicles that she could have, and it's her assertion that the vehicles that were towed were registered, insured, and operable, I'll ask again, do you have any proof from your client for the basis of the tow?
Again, it would be based on my client having provided her previous discussion as to, one, the nature of the vehicles. One, according to my client, one of the vehicles was completely filled with items. It was an eyesore on the property, and it was an issue. She was notified, Your Honor. My client has the right to tow a vehicle if they so choose, provided that they give someone notice that this vehicle is something that they do not want on the property. That's my client's right. The statute does not prevent my client from towing a vehicle based on my client providing someone notice and saying this vehicle, based on the circumstances, even if it's insured, even if it's registered with the state, they have the right to tow a vehicle, provide someone with the warning that they're going to tow the vehicle, and they have that right to tow the vehicle.
Anything else, Mr. Katz?
Yes, I mean, give me 1 second. Again, a lot of this would require my client's testimony as to their previous discussions as far as the specifics of what Ms. Macklin was told from my client. And like I said, without my client here, it makes it somewhat difficult to provide my client's position on that.
Ms. Macklin, any response?
In response to the items being in the vehicle, I was moving, so I was making trips to move stuff from my previous apartment to the new place. I have the receipt from the moving company that came earlier. Actually, that came that week. However, the truck was full, so I did load items into my vehicles to move them to the new house that I was moving into. So that's why there were items in the vehicle. But my vehicles, like I said, were not an eyesore. And the main concern here is that proper notice was not given. And the lease states that there's no limit to the number of vehicles that I could have on the property at the time. And I did purchase a garage to store the vehicles in. Like I said, I periodically would move the vehicle out just so my kids can get their toys. I would put the vehicle back in, but there was a vehicle parked in my garage every day. And like I said, I have the right to file a petition, and I did so because I truly believe that they made an error in their judgment and did not follow the proper procedure to have this deemed as a correct toll.
Based on the comments made this morning, the court is going to grant the plaintiff's petition, find that the toll was not proper or reasonable, and order Pine Woods to reimburse the defendant $684. I'm sorry, $684, the amount previously paid for the toll. The civil department will prepare an order and mail it to the parties at their addresses of record.
Thank you. Thank you
Have a
very
good
much.
day.
Thank you.
Mary Ann, would you pull in Blankenship and Berta, please? Thank you. This is 200545 SC, Craig Blankenship versus Dennis Berta.
Yes, sir.
Good morning, Mr. Berta.
Good morning.
I'm looking for Craig Blankenship.
I'm right here.
I can't see you. Would you mind turning on your video for me, please?
Oh. There we go.
Good morning.
Morning.
This matter is scheduled for a hearing on a small claims case.
Yes.
It was previously scheduled with the court's magistrate. It appears that a non-appearance default entered August 6, 2020. And one of the parties objected and requested another hearing, so here we are. Are you ready to proceed this morning?
Yes. Yes.
Please raise your right hands. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I did.
Thank you. You can put your hands down. Mr. Blankenship, it's your claim. Why are we here this morning?
I loaned Dennis Berta some money. He worked some of it off, made some payments back on an interest-free loan. His daughter and I had a falling out. He took it upon himself to say the debt was paid in full because he had to help his daughter. I've done my part taking care of his daughter, and I haven't been compensated for the money that I loaned him for his vacation home in Jackson. In my opinion, he still owes me $6,000. I have documentation in his handwriting showing each payment and the hours worked until the payment stopped. And I've given, I faxed over a text message this morning, and when he declared that he was going to stop giving payment because his daughter and I split up.
I'm sorry, Mr. Blankenship, you faxed to the court, true?
Yeah, I did with the case number and stuff.
Okay, it hasn't made it to the file. I'm gonna have you keep providing testimony. I'll have my secretary contact the civil department and see if they have the facts.
Okay.
So you were dating, I'm sorry, you were dating the defendant's daughter
Yeah, we have 2 kids together.
and you loaned him $6,000.
I loaned him 12 and I allowed him to work some of it off. He mowed lawns, fixed drywall, did projects with his daughter. Whatever he deemed fitting for his labor and time, he wrote down and documented in his own handwriting. That's the packet you had in the file with the dates and the amounts and the hours worked. Right up until he quit making payments. And on the last page, in his handwriting himself, he has that he owed $6,795. He quit making payments after his daughter and I split up. I took care of my situation with his daughter. I give her $4,000 a month. I paid my child support. I don't see where the money I loaned him had to go to his daughter. I was just asking for what's left of the balance back so I could put it back in my savings.
And is your position that there's still $6,795 due and owing?
Yes.
You're looking for the facts right now. I do have your affidavit and claim, as well as the handwritten 1, 2, 3, 4, 5 pages that show an accounting of work done on the property.
Right. This is all in Dennis's handwriting. This is everything he's provided me for work supplied back towards the balance. And this was an interest-free loan. You know, in the middle of this, I helped him with a washer dryer. I helped him get his truck lease. You know, we had a friendly relationship going on right until the end when I believe he became spiteful because of his daughter and I. In the last hearing, he claimed that I dropped one instance is that I dropped the debt owed. The other instance that it was paid in full and the work that he had to do to help his daughter out. And the other instance was there was some sort of trade-off that's not documented in his receipts. I don't agree to any of that. I do agree that he at least owes me $6,000. And I was just asking for the balance there.
Anything else, Mr. Blankenship?
That's about all I have this time.
Thank you. They're looking for the fax. It wasn't in the civil department. They're checking at another fax machine in the office in the courthouse. So if they receive it, if they can locate it, they'll bring it in, okay?
Okay, thank you.
Thank you. Mr. Birdie, your position.
I was under the attention that on the last hearing we had with the other judge, he was told to hire an attorney, and I was told to wait for his attorney to talk, and then we were supposed to work it out, which was on 9/15. He had 60 days for another review. Nothing happened, so I requested this hearing. I'm not sure why Mr. Blankenship didn't act in 60 days when the judge ordered it. He told us both to talk to attorneys and hire them.
This is a small claims case. It's still showing as a small claims case. Attorneys aren't allowed in small claims court.
Well,
I'm looking at the,
I'm sorry. Part of the reason was Mr. Blankenship didn't tell the attorney he talked to the first time, and I told the judge I did work this off. I met him on March 11th in 2019 at Applebee's, and he agreed to write down any work that I never billed him for, which I have in documentation, and a witness knowing that I did the work, and it comes to well over $8,875 that I never billed him for, but $2,550 of it is for Vicodins that he got from me that he told me to charge him for. And I have text messages proving that.
Mr. Berta, I don't know that you want to give testimony on YouTube that's being recorded that you're selling prescription drugs. I'm just going to advise you that that's probably not the conversation you want to have with the court this morning.
Well, that's why I thought we were supposed to get with attorneys and work it out with attorneys privately. That's the way the judge I took it. Because I brought it up last time with the judge and he told Mr. Blankenship, well, I think you better re-talk to your attorney because I'm sure you didn't mention these pills.
The note that I have is that the matter had not been settled and that the parties were requesting a new hearing date. That is why we're here this morning. Again, attorneys are not allowed to appear in small claims court. People are allowed to represent themselves. And that's why I swore you in and started taking testimony this morning. And it's Mr. Blankenship's position that you borrowed $12,000, that you paid off some, and in the court's file going back over a year now is this 5 pages of handwritten information regarding the work that was done that was to offset the loan. If you have something else you'd like to submit to the court,
I
that
absolutely
you believe adequately present your position that this debt was paid off. I'd like to see it. Have you sent it over? Have you filed it with the court?
No, my understanding was from the judge on the last hearing was that an attorneys were going to be involved and all this information was going to be presented then.
Mr. Berta, the court file indicates that on February 16th, 2021, a civil department clerk mailed a notice to you that's scheduled today as a hearing on the small claims matter. Did you
Which
receive that? No.
I'm sorry. I requested this hearing actually.
So you received notice that the parties were to appear this morning for a hearing,
Yes,
and you noticed that there were no attorneys listed on there.
right, because I was going to request a dismissal at this point because he was asked to do it in 60 days. And nothing happened in 60 days. It's been 7 months since our last hearing. Mr. Blankenship was supposed to get an attorney. The attorney was supposed to contact me, and then that's the way I understood it. And I talked to an attorney, and he said to wait for Mr. Blankenship's attorney to contact me. And it never happened. So time went on. So I requested this hearing because nothing was being done. So I'm asking for a complete dismissal because he didn't act in 60 days when he was ordered by the judge to do it.
There is no order in the court's file for the parties to retain counsel. I'm looking in the file right now. What I see is July 21st, 2020, there's a notation from mediator Al Hemmon that the default will enter. After that is a notice of entry of default judgment from July 23rd. Then there is a judgment which is signed by Judge Oakley, August 6, 2020. And then there's a notation, objection received prior to signing, set for hearing. That was August 6th. There's a July 27th letter from you, Mr. Berta, that you're objecting to all the charges of default and you're requesting another Zoom hearing. I don't see anything in the court's file that indicates that A, the parties are to appear with counsel, or B, that a dismissal would be entered if attorneys weren't retained on behalf of the parties. So we're here about a debt, and my question to you remains, do you have some proof that you like to submit to the court that shows that the amount due is any different than what Mr. Blankenship's alleging?
Absolutely. Absolutely. I have all the documentation.
Okay. Today is the day and time set for the hearing. You've been sworn in. I start taking testimony. Where are the documents?
I did not know what was supposed to fax anything to the courts. I was under the assumption this was going to be done through attorneys back and forth. That's the way I understood it. On 9/15, when we had the last hearing, he said it's going to be a 60-day review. And he even suggested Mr. Blankenship contact his attorney and tell him about the so-called pills. And I know I shouldn't be on here doing that, but that was part of the repayment. And I know I can get in trouble for it. I understand that.
And you heard me advise you not to discuss that matter on YouTube during the course of a hearing. Okay.
Yes.
Okay.
Yes. I'm willing to take that to whatever it's whatever happens to me, that's on me. But this was part of the repayment, and that's what he asked for. And that part of that is $2,550, which I have every text from him, him requesting them.
Mr. Burt, the issue is because this is small claims, we relax a little bit, but not completely, and we still need proof. What the court has is an affidavit of small claims where Mr. Blankenship asserts that there's this money due from you, just over $6,000, just shy of $7,000. He also provided this ledger showing where the money was worked off. So if you have documents you'd like to present, we can make arrangements to receive them by fax,
Yes.
by email. You can drop off a copy, but we're here scheduled and proceeding this morning. So how do you propose to get the documents to the court?
I can drop them off personally. I mean,
Drop
I
them
can't
off.
do it. right now, but I mean, is that what you're asking? I'm not sure.
Well, I'm suggesting that Mr. Blankenship's already put his position on the record. If there are documents you'd like the court to consider,
Yes.
okay. So when can you get those documents submitted?
Today or tomorrow, probably today. Problem is, Judge, the last time I dropped stuff off at the court and fax stuff, just like you can't find his, that's why there was a judgment against me. I didn't get the Zoom hearing information until the day of the last Zoom meeting. My mail runs at 3:30 in the evening. It was 9 o'clock that morning that I was supposed to have a Zoom. That's why I contacted an attorney and he told me how to go through and request another hearing against the default judgment.
Well, Mr. Berta, and that's why I say I understand, and Zoom is different for people, and they don't know sometimes that they can mail the documents in or email them to the civil department, they'll make it to the file. And because Mr. Blankenship's document has also not shown up, what we can do, if the parties are in agreement, we can adjourn this matter. We can pick up the testimony again. I'll have Mary Ann look to see what's going on next Tuesday. If that would be a good day for both of you, and we can resume this matter that day at that time. I believe that we have everyone's phone number so that we can contact you and provide a method for you to get the documents in, either drop them off, you can mail them.
I'd rather do it in person, just drop them off. But I understand it's a Dropbox and that's where everything got lost last time. Is there
We
different
actually
ways I
have,
can do it?
our
to
court
ensure it gets
officers are
done?
actually here. They prefer people use the Dropbox because, again, COVID-19 being what it is. But if you put something in the Dropbox with this case number on it and indicate that it's the exhibits for or evidence for the hearing, I'm looking for it, the civil department's looking for it, it should make it to the file in a reasonably short period of time.
Okay. I'll do that. I can put it in the Dropbox.
Mr. Blankenship, do you have any objection to continuing this matter?
Is there any way that we could just get this over with today? It's been dragged on quite a bit. He was supposed to get an attorney to go after these text messages he has and whatnot. But I think we've taken enough time of yours and Judge Allen's and everybody else's. Could we just resolve this today?
Well, Mr. Blankenship, I'm sure you heard me say that we've been unable to locate what you allege that you faxed over to the court. It's something that you wanted me to consider this morning.
Yeah,
Mr. Berta has been unable to present or submit the documents that he wants the court to review as well. And I understand that this matter has been pending since last January. But again, COVID being what it is, Zoom being what it is, and the parties not being familiar with the process, I'm going to find that there's good reason to continue this matter. If the parties can reappear next Tuesday, which would be April the 13th.
I can, no problem.
Is 9 o'clock good?
Yes, ma'am.
Yes, ma'am.
We will continue to 4/13/2021 at 9 a.m. The case will remain with me. We have a phone number for Mr. Berta that ends 6464,
Correct.
and for Mr. Blankenship 0174.
Yes, Your Honor.
Okay, you can follow up if there are documents that need to be submitted. We'll make sure that you know how to submit them. Fax, drop off, email. We'll get that resolved after the docket's finished this morning. Okay.
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 Anything else for right now?
No,
No,
ma'am.
ma'am.
Thank you. We'll see you both next Tuesday morning.
Thank you.
Thank you. Is somebody here for Preston, Nate, and Woolham? Thank you. Oh, I think that might be the 9:15 or 9:30. Ms. Hampton?
Yes.
Okay,
You hear me?
I can hear you, ma'am.
Okay, I'm sorry.
Want to make sure that this was in fact the right case, and then I don't know if Miss let's just look in the file. If Miss Francis is here for Universal. Good morning, ma'am.
Good morning, Judge.
We don't have a match pair yet. I see that you're here for the Citibank matter.
Yes.
I don't see Miss Woolham yet. We'll keep you back. We'll put you back in the waiting room for now. Give her a little longer to appear.
Thank you, Judge.
No problem. Thank you, ma'am. Ms. Hampton,
Yes.
we're gonna put you back in the waiting room. There's no attorney checked in yet. Your matter's not scheduled till 9:30. It's 9:18. We allow
Oh.
people a little bit of time to get checked in, okay?
Yes, ma'am. Thank you.
Thank you. Well, JT told me that their attorney is Stidham. I didn't see an appearance in the file with that name. And I I pulled them in to make sure who they were. They're represented. I want to see where their attorney is, and it's still scheduled for 9:30. So we don't have any match set as of yet. And we'll sit tight for a minute. Thank you, Mr. Bell. You too, sir. Thank you. As soon as we have a match set, or the 9 o'clock default maybe, then we need to work out a process for documents to be submitted. Did you look at the template for the 13th? Oh, thank you. Okay. There's nothing. Thank you. We're just watching the waiting room populate. Did you bring Ms. Hampton back in?
Yes.
Ms. Hampton, do you have video available? Thank you. I am calling 210308 GC Universal Collections versus Kia Hampton. Your appearances, please.
Good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722.
Your name, ma'am?
Takia Hampton.
Good morning again, Ms. Hampton. This matter is scheduled for pretrial. Would it be helpful to the parties to discuss, or have the parties had an opportunity to discuss this matter?
Your Honor, I have not spoken with Ms. Hampton. However, I believe she has an attorney on this.
Yes, I do.
Thank you.
Yeah,
I don't see an attorney listed on the ROA. Give me one moment.
sure.
Nick Bulberman's office.
Yes, ma'am.
Yes.
Thank you. I don't see Mr. Bulberman or Mr. Munson. Ms. Hampton, we're gonna put the parties back into the waiting room.
Sounds good.
If you can get a hold of your attorney.
Okay.
Why is there no appearance?
Yeah, I did show an answer filed by them, but no appearance. So,
It's one and the same, it's just not appearing on the ROA.
okay, gotcha.
Thank you.
Well, I haven't seen you in a while. Congratulations on becoming a judge.
Thank you, sir. It has been a long while.
I know.
Marion's gonna put you both back into the waiting room, and as
Okay.
soon as someone's here from Mr. Bulberman's office.
Yep.
So ready when we have a match, and then the question becomes, how late can you be before you're defaulted? I think a half an hour is a reasonable amount of time. And I want to make sure that we look through the file. This is a Citibank matter that I'm looking at. That is what she's here on at 9:30. If the defendant hasn't checked in, I'll call the case and I'll continue to monitor for this other matter. I made a note on the file to have the attorney added to the ROA for Ms. Hampton. When I opened the file, I just saw the top of the register and didn't see. Stidham is for JT Towing. You can, because I saw the attorney. The attorney is here for auto owners, and we'll see if they need to chat. We'll see. Good morning.
Good morning, Your Honor.
This is 210790 Auto Owners versus J&T Towing. Mr. Stidham,
Yes. Good morning, Your Honor. Thomas Stidham appearing on behalf of J&T Towing, doing business as Prova.
what I was gonna say is that there's someone here from J&T. They've been here since about 8:45.
Right.
I wanted to check with you, the attorneys, to see if you needed to speak before this matter was officially called.
Oh, thank you. No, Your Honor. They're available to testify if the court wants to hear testimony.
Do you need to speak to the other attorney? The attorney for auto owners is my question.
Oh, I'm sorry. I'm sorry.
I didn't say it artfully, I'm sorry.
Yeah, no, I don't believe so, Your Honor. I haven't spoken to counsel yet, but I don't think so.
You haven't spoken to him and you don't think it would be helpful to speak this morning? You don't have to. I just want to be clear because
Yeah, I will. I guess it would be prudent for us to speak, Your Honor. Yeah, I would like to speak to him because I've never spoken to him before. So
Marianne, I'll move you into a breakout room. There's only
Thank
one matter ahead of you. Thank you, Marianne.
thank you, Judge.
Not a problem. This is 210154 GC Citibank versus Diana Willem. Your appearance, please.
Good morning, Your Honor. Navjot Francis on behalf of Plaintiff's Attorney of Record P72322.
Thank you, ma'am. This matter was scheduled for a pretrial at 9 o'clock. Ms. Willem has not checked in. There is no one by the name of Diana Willem or anyone unaccounted for in the court's virtual waiting room. How do you wish to proceed this morning?
Judge, I just reviewed the notes and it seems we have come to a resolution on the matter with the defendant. However, we have not received a consent judgment signed and returned. So maybe if we could do a default judgment under the 7-day, and if we get the consent judgment before that, we will submit that instead.
Thank you, ma'am. I'll make a notation in the file that one or the other, either the default or the fully executed consent judgment will be filed. Anything else in this matter this morning?
No, Judge.
Thank you, Ms. Francis. Have a good day.
You too. Nice to see you, Judge.
Good to see you. Good morning, Mr. Munson.
Good morning, Your Honor.
Your client is here. Marianne is going to pull her in just 1 second. Did you need to speak to the attorney from Universal Collections?
Yeah, I think just briefly.
Yeah, that's fine.
Marianne, I'll move you into a breakout room.
Thanks, Judge.
Not a problem. Ms. Hampton, your attorney is here. He's in a breakout room with the attorney from Universal Collections. Okay?
Oh, yes, ma'am.
Thank you, ma'am. I see it. Thank you, ma'am. I have an idea. Are the parties ready to proceed in Universal versus Hampton?
Yes, Your Honor.
Calling 210308 GC Universal Collections versus Hampton. Your appearances, please.
Good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722.
Good morning, Grant Munson, P71994 for the defendant, who is present via Zoom today.
Matter has been scheduled for pretrial this morning. Are the parties able to reach a resolution?
Yes, Your Honor. I feel quite confident we'll be able to resolve this. We have not yet. We're just hoping to maybe get a little bit of time to get it resolved. I know plaintiff, we have filed a motion for summary. If we could get a date for that, we would appreciate it as well.
Yeah, Your Honor, we'd request 60 days discovery, and then if we could set a date for the plaintiff's motion after that point, I think we'll be able to get it resolved by then.
There's a notation on the ROA that the motion for summary disposition has been scheduled for May the 4th at 9:30 a.m.
Oh.
Had not gotten a notice of that.
Yeah, neither had we.
That's the note I see as of 3/16, but if that's not a good date based on the parties requesting 60 days discovery.
No, if we could get a date after the 60 days, it would be preferable, Your Honor.
Yeah.
It'll be that first Tuesday in June.
That works for me, Your Honor.
Works for me as well.
whatever that number is. I don't have the calendar.
I believe it's this, oh no, wait. The first, I
When you,
believe.
is that what it is? The first Tuesdays? Okay.
It is, so maybe the 8th.
I only do civil on the first Tuesday.
Oh,
June 1st is the date. June 1st, 2021 at 9 a.m. for the motion for summary.
Perfect.
60 days discovery. If you want to send over an order granting discovery,
Yes, Your Honor, sure.
thank you. Anything else?
I don't believe so, Your Honor.
We'll see you back here on June the 1st unless you resolve it before.
Thanks, Judge. Have a great day. Stay safe.
Thank you. You too. Good to see you, Mr. Munson.
thank you. Good to see you as well. Have a good day.
You too. Are the parties ready on auto owners and J&T?
Your Honor, we just need a couple more minutes. We're still having some discussion. I have to contact my client if that's permissible.
You want back in the breakout room or are you going to stay here muted?
I'll just mute and stay here if court would.
That's
allow
fine.
that.
Thank
Okay.
you. Mary Ann, you want to find out who Big Lou is?
The person who has Big Lou's note, can you hear me?
Thank you. I think it's Mr. Vasquez. My question of the day is how many what's the maximum open active Zoom courtrooms an attorney has been waiting in? Someone posted the other day on social media that they were in 7. I don't believe that that's possible. I guess anything's possible, but that sounds like a lot.
Yeah, it's really the computer can handle it. Usually mine freezes up after a couple instances of going on. Imagine the computer could handle that. I don't know. That's
The
crazy.
most I've ever been in is 3. And that's every device open. So I don't know how.
It'd be tough. We have to make sure there's no feedback too with all of them
Oh, I
going on.
know. Mr. Vasquez? Oh. Was that a response to your chat message? No, he came on the screen, I think, and there's only one unmatched file, and that's why I thought it was, in fact. I haven't seen the attorney on that matter. I haven't seen him in probably 3 years now. Okay.
Good morning, sir, with the red shirt on. Can you hear me?
Are you bringing your presents?
Hi, what is your name, please?
Luis Vasquez.
Thank you.
Thank you. Oh.
Hello?
Oh my goodness. Are you kidding me? Hey, this is going back. Oh my goodness gracious. It's the last thing I want. It is who you think it is.
Here a few times yesterday.
Thank you so much, Tim. Marianne, did you see what he just brought? You laughing is not helpful. Sorry. Or we were waiting for auto owners and JNT. We're ready if you were ready. I thought somebody was calling their client.
I did, Your Honor, and it did not result in a resolution. So
Okay. Marianne, do you want to pull them in? This is 210790GZ, Auto Owners Insurance Company versus J&T Towing, doing business as Crova Towing. Your appearances, please.
Good morning, Your Honor. Jared and Jessica on behalf of the petitioner.
good morning, Your Honor. Thomas Stidham appearing on behalf of J&T Towing.
Mr. Stidham, I don't believe that we have an appearance from you.
I'm sorry, Your Honor. I believe there was an initial appearance that was put in with the envelope in which our brief was filed.
I don't have a brief from you either.
It was hand delivered to the court, Your Honor.
It was hand delivered yesterday.
Yesterday, yes.
I've had the file since last week, so it's loose in the building somewhere. If you sit tight for 1 second, I'll have Marianne check with the civil department.
Sure.
Here's phone dialing already.
Thank you.
It's on its way. Thank you. I don't see a representative here from Van Buren Township Public Safety. Has the plaintiff received the brief submitted by the defendants?
Yes, Your Honor, I received it last night.
Have you had an opportunity to review it?
Yes.
Would you be prepared to proceed this morning?
Yes.
Mr. Stidham, are you prepared to proceed this morning?
Yes, Your Honor.
Court has not received the brief. It is in the building. I see it. It's coming through the door right now. Thank you, ma'am. Mr. Stidham, the civil department clerk just handed me your brief. The brief is actually 10 pages, and then there are some attachments. What I will do right now is step away for just a moment so that I can review your brief. And then I'll come back out, and if the parties are ready to proceed, I'll call the case then, okay?
Yes, Your Honor. Thank you very much.
Thank you.
Morning, Miss Runyon. Can you hear me?
Yes, I can.
Hi. Are you here for Universal Collections?
No, I'm not. I'm here for Shores Financial Group.
For Shores. Okay, that's right. I'm sorry, I misspoke. I'm going to put you in the waiting room, and we'll call you out in just a second. Okay?
Okay, thank you.
Thank you. Miss Runyon, Mr. Vasquez is here. Is there a need for you to go into a breakout room with him?
We can. I have no opposition to that. We can.
Okay.
All
All
right.
right.
Get something worked
Give me
out.
1 second, please. Mr. Vasquez, I'm going to put you in a breakout room with the attorney. When you see an invite to join the breakout room, please click on it.
Okay, I'm new to this Zoom stuff, so I don't know how it's gonna work.
Mr. Stidham, I started reviewing your brief, and as I was halfway through the brief part, they brought in plaintiff's brief to me, which just arrived in yesterday's mail. So I don't want to hold the parties here unnecessarily while I review these matters. So I wanted to check with you to see if both of you are available to hold, or do you want to come back in maybe a half an hour or so? Would your schedules allow that?
That's no problem. Come back in a half hour, Your Honor. I don't have anything till 2 o'clock this afternoon. So.
Your Honor, I don't have a problem coming back. I'll gladly come back in a half hour. My only thing is I have another hearing at 10, but it's a short hearing. It's just a pretrial conference. So I should be clear by 10:30.
If you would come back, zoom back to the same number at 10:30, I'd appreciate it. I have one short pretrial and then I'll leave the bench and review both of these briefs and supporting documents.
Very well. Okay,
Thank you very much. Thank you for your patience this morning. I'll see you at 10:30-ish.
Very well. Thank you, Your Honor.
Thank you.
Thank you.
Bye-bye.
Ms. Ryan, were you moved out or kicked out?
I moved out, but there was only about 1 minute left, and I know Mr. Vasquez doesn't, he said he's kind of new to Zoom, so I think he might be waiting on it to just kick him out, so. But I did tell him that I was going to leave the breakout room, and he said, okay. So I don't know if he's trying to figure it out or, oh, there he is.
I was gonna say she's moving him out.
Okay.
This is 210177 GC Shores Financial Group versus Luis Vasquez. Your appearances, please.
Good morning, Your Honor. Tina Runyon appearing on behalf of Plaintiff Shores Financial Group.
Your name, sir?
Luis Vasquez.
This matter was scheduled for pre-trial conference this morning, and I will note that the parties were in a breakout room having had the opportunity to speak. Were you able to resolve this matter?
No, we did not, Your Honor. We did not come to an agreement today.
The matter was scheduled for pre-trial, but Mr. Vasquez, what the court received from you was a return of the summons and complaint in this matter without any indication on how you were responding to the claim of the plaintiff.
My office received, Your Honor, a letter, it's, you know, form just indicating that Mr. Vasquez is on Social Security. I don't know if I should. It's not redacted.
We received that. We have that in here, the
Oh, you
benefit
did?
verification letter, but we don't have, Mr. Vasquez, did you file an actual, did you file a response to the complaint that you received to the court documents?
No, I haven't received anything. Well, I had a form, something served, but they didn't ask me to respond. I really don't know how this works. So, you know, if you want to respond, I guess. Yeah, my response is that this is, you know, it's happening in another state. And it might be outside the statute of limitations. That's what I advised the plaintiff.
Your Honor, my response to that in our breakout room was that this was not in a different state. I don't even know what state Mr. Vasquez might think this could have occurred in. It's definitely in Michigan and within the statute of limitations. So, and quite frankly, as the pleadings, I mean, if I'll just refer to his Social Security letter as his pleadings for now. I would request that based on that, and it seems like there's no real genuine issue. I would request that the court enter a judgment based on the pleadings, or at this point, we could go through discovery.
Mr. Vasquez?
Yes.
Your response to the request for a discovery or entry of judgment?
Okay. The plaintiff says that that this occurred in the state of Michigan. In 2015, as she alleges, I was living in Brooklyn, New York. I didn't move to Michigan until 2016. So this is not something that happened in Michigan.
Ms. Ryan, I'm going to deny your request for entry of a judgment at this time. The court doesn't have any documents in the file that would support statements you made regarding when or where the underlying count was alleged to have originated. If you do wish to have discovery, how long of a period of discovery?
I would request 60 days, Your Honor. I think that would be sufficient.
Mr. Vasquez, do you have any objection to the entry of an order for discovery?
I really don't know what an order for discovery means, but is it something to get all facts together or something? I'm not quite sure.
Correct. It's an opportunity for the plaintiff's attorney to submit written questions to you, requests for documents, et cetera, to you, and you would have to respond to it. And you could similarly do the same. You could submit written requests for answers to certain questions, requests for production of documents, whatever you need to get your position together and present it to the court.
That's fine, Your Honor.
The court will grant 60 days discovery. Ms. Ryan, if your office will submit an order.
Yes, I can do that, Your Honor. And I do have a question regarding motions. If once our discovery is completed, I assume that the court will probably set a final pretrial date. Is that correct?
That's correct.
Okay. Now, if we do decide to file a motion on this matter, could that be heard at the same date and time as the final pretrial, or would you prefer that we wait to file those motions?
We're doing 60 days discovery. That will put us at first week of June. Our next civil day, well, our civil day is the first Tuesday of the month, and that first Tuesday in June will be June 1st. So if you want to file your motion at that time, if you want to notice it for that time, I'll hear it at that time.
Okay.
But if you wait and discovery hasn't started, or you have issues outstanding, you might want to consider doing that in July. But for right now, I'll put the motion, the final pretrial for June the 1st, 2021 at 9 a.m. Mr. Vasquez, I would suggest to you that I'm not sure if you have or not, sought legal assistance in this matter so that you can respond to any documents that you receive in this matter.
Oh, I have not tried legal representation yet.
Okay.
I don't know, it seems a simple case that this does not happen in Michigan. That I can prove for sure.
Okay. Well, for right now, the court is going to grant the 60 days discovery. You're probably going to receive a copy of the order that the plaintiff's attorney is submitting to the court for review. Thereafter, discovery will be open for a period of 60 days. The next time the parties will be back will be June 1st at 9 a.m. The civil department will mail you notice of that hearing.
Yes, Your Honor.
We'll see you back here. Well, I'm guessing that we'll still be on Zoom. We'll see you back here at that time. Anything else, Ms. Ryan?
No, that's all, Your Honor.
Anything else, Mr. Vasquez?
No, Your Honor.
Thank you. We're all set. Have a good day.
Thank you too. Bye-bye.
Marianne, I'm not sure if you were out. I received the plaintiff's brief in the auto owners matter. So I asked them to come back in a half an hour. And I see Jeremy Chisholm for Reliable Auto Finance. I don't know who that is or why they're here. Thank you. Good morning, Mr. Chisholm.
Good morning, Your Honor. How are you this morning, Judge?
I'm wonderful. What are you here for?
Judge, I have a notice to appear for an objection. Well, the defendant filed a motion for installment payments, and my client, Reliable Auto Finance, filed an objection to that hearing, or to that motion.
Do you have your notice to appear?
I do, Your Honor.
Are you with me, or is it somewhere else? I don't have.
You know what's quite odd, Your Honor, is that it lists Judge David Parrott as the judge, but the instructions instruct me to your Zoom room.
What's the case number?
Case number, Your Honor, is 19-2752 GC.
Marianne is looking that matter up and she's gonna get back to you.
Thank you, Your Honor.
But sit tight right there where you are.
Sounds good.
Thank you. Mr. Chisholm,
Yes, Your Honor.
it is scheduled for 10 o'clock. It was just added. She brought the file down to me. I'm reviewing some documents in the other matter. I'll call your case at 10:25 or so. If there's something else you want to do.
That's all right. I'll hang out here and work from and have this in the background if that's all right with you.
That's fine with me. Thank you.
Thank you.
Back on the record. 19-2052 GC Reliable Auto Finance versus Antoinette Bracy.
Good morning, Your Honor. Jeremy Chisholm, P74670. I am the attorney of record for the plaintiff.
Mr. Chisholm, do you have?
I'm sorry, Your Honor. I lost you there.
Do you have video?
I do not, Judge. It's on right now, and apparently it's not working. I'm actually up in Traverse City at the moment, kids' spring break, and I'm not exactly sure why it's not working, but we're trying here.
Yeah. You're in Traverse City for spring break and you can't get your video on.
Judge, actually, I had it working yesterday.
It's fine. I'm just giving you a hard time.
Without the ladies helping me get the IT functioning, I'm darn near useless.
The file was brought down to me, and this matter was scheduled for hearing on the defendant's motion for installment payments that was filed on February 1st, 2021. There's a response and objection from plaintiff's attorney on February 17th, 2021. The clerk of the civil department mailed out notice to appear on February 18th, 2021, setting this matter for 10 a.m. It's 10:31 by the court's clock. I'm checking the virtual waiting room. There is no one by the name of Antoinette Bracy, any derivative thereof, or any party that we haven't already matched to another file. Mr. Chisholm, how do you wish to proceed this morning?
Your Honor, I would ask that for the reason stated in our objection, and for the fact that the defendant has failed to appear for their own motion here, I would ask that the motion be denied, Judge.
Inasmuch as Bracy has failed to appear this morning, given the fact that the proposed monthly payment included in her motion will require more than 20 years to satisfy the judgment previously entered in this matter, and its motion for installment payments will be denied. Anything else, Mr. Chisholm?
No, Your Honor. Thank you for your time this morning.
You have a good day, sir. Thank you.
You too, Judge. Thanks a lot.
Yes, ma'am. Thank you.
Turn the meet back on.
Recalling 2107990 GZ Auto Owners Insurance Company versus J&T Towing, doing business as Prova Towing.
Good morning, Your Honor. Jared and Jessica on behalf of the petitioner.
Good morning, Your Honor. Thomas Stidham appearing on behalf of the respondent, J&T Towing.
Mr. Stidham, were you finished with your 10 o'clock matter?
I am, Your Honor. Yes, thank you.
I have had the opportunity to read the briefs in support and the response submitted by the petitioner and the respondent. And I am ready to proceed this morning, but before I do, I want to place on the record that I am married to an elected official of Van Buren Township. Although he is not a signatory to the tow agreement that both parties have attached to their pleadings, I at least wanted to place that information on the record.
Your Honor.
It would not impact my judgment or my ruling, any ruling in this matter. Given that, is the petitioner ready to proceed this morning?
Yes, Your Honor.
Is the respondent ready to proceed this morning?
Yes, Your Honor.
Are there any opening statements on behalf of the petitioner?
I'll just state briefly, Your Honor, that in taking the totality of the circumstances here, the towing fees are unreasonable. Essentially, either the Van Buren Township Police Department failed to notify J&T Crova that the vehicle was off a police hold, or J&T Crova failed to notify my client that the vehicle was off the police hold, and the vehicle was unnecessarily stored for almost 480 days when the charges against the at-fault driver, Mr. Bostic, were resolved on September 24th of 2019. The case number associated with those charges was the sole reason listed on the invoice by J&T Crova for the reason why the vehicle was on a police hold. As that case was dismissed on September 24th, 2019, there's no reason that the vehicle should have been placed on a police hold for almost another year and 3 months. And Your Honor, in just looking at the totality of circumstances, that's why we brought forth this hearing, that the towing and storage fees are just wholly unreasonable.
Mr. Stidham?
Thank you, Your Honor. First of all, there is nothing unreasonable about the fees based on the facts and circumstances that occurred here. This is a very routine matter in the towing world, in which a vehicle was involved in an accident. The police, when the vehicle came in, as the court will hear, there was not a hold on it initially. A hold was subsequently placed on the vehicle upon the passage of the driver of one of the vehicles. And that's the vehicle at issue here, a 2015 Chevy Equinox. Subsequent to that, the hold remained, and as the court will hear from the testimony from the Bokens, the manner in which a police hold is placed and released occurs it's solely the province of the Van Buren Police Department. Van Buren did not notify the J&T towing, the court will hear, until such time as January of 2021, the vehicle to release the hold. And there's nothing unreasonable about the fees. First of all, it's a matter of contract, as the court will hear. Secondly, the fees in other area and other localities, similar areas, are in line and in conformity with the fees that were charged here. And lastly, Your Honor, I would be remiss if I didn't point out to the court that the plaintiff's petition is untimely under the statute, MCL 257252D, and I'm sorry, and A 14. It has to be filed within 14 days. This petition was filed 16 days too late, as we've outlined in our brief. And based on the published Court of Appeals authority there, we don't even believe that the court has the authority to hear or decide this matter as a matter of law. So thank you, Your Honor.
Are there any witnesses that the petitioner will be presented?
No, Your Honor. I'll just make a state for the record, pursuant to the statute of MCL 257.252F, it's the burden of the towing agency as well as the police agency to establish that they complied with the statute.
Mr. Stidham?
Yes, Your Honor. We have two witnesses, Dawn and John Boken.
Mr. and Mrs. Boken, would you raise your right hands, please? You swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Stidham?
Thank you. May I proceed, Your Honor?
Yes, please.
First of all, I'd like to address, I don't know procedurally, Your Honor, how does the court, may I ask each witness questions, or do you just want to have me summarize their, I just want to get some guidance as to, like a normal trial? That's all I'm asking.
Normal trial.
Okay.
I'm aware of the statutory provision that the reasonableness rests with the reasonableness of the tow, and the fees rest with the respondent towing agency. This is not my first towing case, so
right.
If you would just question them as you would normally.
Okay, thank you, Judge. First of all, I would like to start with the respondent. We'll call it Dawn Boken, please. And Ms. Boken, can you first of all state your name and tell the court what your role at J&T Towing is?
Yes, my name is Dawn Bokan. I'm office manager and owner of J&T Towing.
Okay, and are you familiar, Ms. Boken, with a 2015 Chevrolet Equinox that is the subject matter of this proceeding?
Yes.
And was J&T Crova dispatched to tow the 2015 Chevy Equinox?
Yes.
And by whom?
Van Buren Police Department.
Okay, and do you recall the reason the vehicle was towed?
Accident, but they don't tell us at the time of the tow. We just know we have to respond for a dispatch call. Subsequently, I found out it was due to an accident.
And when the vehicle was brought in, the Chevy Equinox was brought into J&T Towing, was there a police hold that was placed on the vehicle?
At the time that it came into the lot, there was no hold on the vehicle.
Okay, and can you explain for the court how police holds work with respect to Van Buren Township?
So Van Buren governs all of our tows due to the process of a release form. So whether or not a hold is placed on a vehicle, each person or towing company or insurance company that's required to pick up a vehicle from our lot would need to go to Van Buren Police Department and get a release form for the vehicle. Once they did that, they would bring it here to our towing company and we would release it.
And how is J&T Crova notified, or I'm sorry, J&T Towing notified that there's a police hold on a vehicle?
Well, in this particular instance, the officer called on October, I think it was October 22nd, or excuse me on the date. They called the evening, the person driving the vehicle had passed away at 11:35. Officer Lucas called us and placed a hold on the vehicle.
Okay. And did anyone from Van Buren Township subsequently notify J&T Towing to remove the hold?
No.
When was J&T Towing notified to remove the hold?
Once a release form was given to the towing company that picked it up, we then receive an email over the internet that the vehicle is going to be released.
And you received the email from the Van Buren Police Department?
Correct.
Okay. And are you familiar with the form that the Secretary of State issues called a TR-52L?
Yes.
And can you describe for the court what that form is?
That form notifies the registered owner or the credit company that the vehicle, if they didn't know where it was, where it's being held at.
And do you have a copy of the TR-52L form that was issued in this case?
Yes, yes, I do.
And can you tell the court what was the date of that TR-52L? What was the date it was issued? By the Secretary of State?
January 4th, 2021.
And was the vehicle subsequently redeemed after that date?
Yes.
And when was it redeemed?
Sorry, I'm just looking through my paper.
Do you have a copy of the J&T invoice number?
I do.
And can you can you describe for the court what you're looking at?
I am looking at our actual invoice to release the vehicle.
And What is the invoice number?
Invoice number 240251,
And what was the date of the invoice?
1/7/2021.
And how much was the invoice for?
$12,304.20.
And how much of that invoice was storage?
$12,000.
Okay. And how is the storage calculated? Ms. Spoke.
It's calculated daily at the rate of $25 per day.
Did you have an opportunity to review the plaintiff's, or I'm sorry, the petitioner's brief in this matter?
Yes.
Did you see some notes or screenshots in the brief? It's, I believe, Exhibit E that identify Copart lot display lot notes.
Yes.
Have you had a chance to look at those?
Yes, I have.
These lot notes seem to suggest on many entries that J&T Towing informed the caller. It appears to me that J&T is referred to as the shop, informed the caller who was calling about this vehicle that they had to, on a couple instances, contact the police department. Is that
Correct.
consistent with what J&T Towing would tell someone normally in the normal course of its operations?
Yes, because it does require a release form. We have to inform them to contact Van Buren Police Department because regardless if it has a hold or not, it requires a release. So we tell everybody that calls, they will have to contact the Van Buren Police Department in this instant to see if they can get a release form for it.
And Ms. Spoken, looking at these notes, these Copart notes, do you know, or first of all, you've reviewed the documents in connection with this case, correct?
Yes.
And I just want to ask you about a couple of them to highlight a couple things for the court. I'm sorry. Attached to the exhibit, to the respondent's exhibit D, is the petition that you received in the mail contesting the reasonableness of the fees, correct?
Correct.
And can you tell the court what the date of the petition is?
Let me make sure. Okay, the date of the petition.
It's the timestamp on the right-hand side.
February 9th, 2021.
Okay, and next I'm going to direct your attention to, this is Respondent's Exhibit E. And the petitioner also attached it as an exhibit. And this is a towing service agreement. Do you recognize that document?
Yes.
And is that the agreement between the Charter Township of Van Buren and J&T Towing?
Yes.
And that agreement governs the manner in which J&T Towing provides services to the township. Is that correct?
Correct.
And as part of that agreement, does J&T Towing have an obligation to provide the township with weekly reports of vehicles that are on hold?
Yes.
And did J&T Towing provide those weekly reports to the township of Van Buren during this period of time?
Yes, every week.
Every week. And I'm going to turn your attention, Ms. Spoken, to Respondent's Exhibit F.
Yes.
The very first page is a email header. It says from J&T Towing to Jeff, I'm sorry, Galui, dated October 8th, 2019. Do you have that in front of you?
Yes.
And can you tell the court what you attached or what you sent Mr. Galui on October 8th, 2019?
Yes, the weekly impound inventory.
And on the weekly impound inventory, is that page 2 of that exhibit?
Yes.
And this is where you list the vehicles that are on hold.
Yes.
And is the 2000 Chevy Equinox listed on this vehicle, on this sheet?
Yes.
Okay. And each page that comprises the remainder of this exhibit, these are weekly impound reports that you sent to Officer Galui. Is that who you send them to each week?
Yes. Correct.
And this is from the period after September 24th of 2019 until the vehicle was redeemed?
Yes.
And in each one of those reports, is the 2015 Chevy Equinox identified on the list of vehicles?
Yes, it is.
Okay. And lastly, Ms. Boca, I'm going to ask you just to go back to Respondents Exhibit A. And can you just identify for the court what that is?
Copart title transmittal?
No, the Respondents Exhibit A.
Oh, the respondents. I might not have that in front of me.
Well, let me ask you, let me just see if I can clarify. Does the Van Buren Police issue a impound slip
Yes,
upon each tow?
correct, yes,
And did they do so in this case?
yes.
And do you know who Adam Bird is?
Yes, he's a police officer for Van Buren Police Department.
Okay. And was Adam Bird the officer that impounded this vehicle? The 2015 Chevy Equinox that we're discussing today?
Yes, he was.
Okay.
I have the exhibit in front of me now, sorry.
Exhibit A?
Yes,
And do you see at the top, it says, on my copy, it says impound slip. Is that your handwriting?
that is mine.
Okay. So you wrote that for me, correct?
Correct.
But below it is the actual impound slip that was issued by the Van Buren Police Department that has the details of this tow, correct?
Correct.
Okay. Now, Ms. Boken, I'm going to go back and ask you, with respect to, and I'm jumping now. Now I'm back to these Copart notes that were attached to the petitioner's petition.
Okay.
And I'm going to ask that you find the note. Did you have those in front of you?
Yes.
Okay. I'm going to direct your attention to the note dated 10/16 of 19, October 16, 2019.
I don't have it. Excuse me. Tom, we don't have that here. If you want to send it to me real quick on a PDF or to my phone, I could show it to him real quick. I'm sorry.
That's okay.
Let's look at that. Stay for the
Who is
record.
that?
There's identified.
That's
my name-
another principal of the corporation, Your Honor.
Sorry. My name's Louis. I'm sorry. I couldn't fit on the screen.
It's okay. I'll proceed. Ms. Boken, there's a note on this that's in the middle of the middle of this petitioner's exhibit of 10/16/19 that I'm going to ask you to explain.
Okay.
It says XML note. The police stated this vehicle is released for pickup.
Wait, I'm sorry, Mr. Stidham,
Yes,
you said 10/16/19?
10/16/19, Your Honor. Yeah, it's about 5 pages on my copy from the end of the exhibit. In the petitioner's exhibit E.
Thank you, I was on the wrong page, okay.
And again, my question is, it says, the police stated this vehicle is released for pickup. What does that mean to you?
That the hold was removed and they could go over and get a release form and pick up this vehicle.
Did anyone notify J&T Crova that a hold had actually been released?
No,
Whose obligation, or this is my question. If a hold had been released by the police department, would they have notified J&T Towing?
only through a release form.
Did J&T Towing ever receive a release form for this 2015 Chevy Equinox prior to January 7th of 2021?
No,
Is it possible that this entry, that in the petitioner's own entry where their agent is saying the vehicle is released for hold, is it possible this is an error?
no, I wouldn't think so.
Okay. Thank you, Ms. Spoken. I have nothing further for her, Your Honor.
Any questions, Mr. Andruski?
Yes, Your Honor. When was J&T Crova notified via email that the police hold was off?
It would have been the same day the vehicle was released and they brought the release form. So that would have been 1/7/2021.
But previous you stated you were notified via email, correct?
Correct. So once a release form is received or they received it, the tow company that was picking it up, we get an email, we get a duplicate of the release form.
And that was on January 7th of 2021, correct?
Let me look at the release form. Release form. The release form was generated on 1/7/2021.
And when did J&T Crova send the TRL form to the Secretary of State?
We don't.
Then do you know who submitted that form?
Van Buren Police Department.
Did J&T Crova ever notify the police department that the vehicle was abandoned?
They take care of that via the weekly reports we send in. So Van Buren Police Department handles all of that.
And when's the last weekly report that J&T Crova sent to Van Buren Township?
Last week.
In regards to this vehicle, when was the last time?
It would have been a week prior to it leaving us.
And that was not included in the previous exhibit you examined, correct?
Correct. We just gave random and show it was on there throughout the period.
And you can't release a vehicle until Van Buren Township releases it, correct?
Correct.
And on your invoice, in the states, there's a reason category, correct?
Yes.
And on the reason, it states 19-17285, is that correct?
Correct.
And are you aware that it's the same case number associated with the civil infractions charged to Mr. Bostic?
I have no idea what they're charged with. It's the case number that governs this vehicle being impounded.
And that's provided to you by the Van Buren Township Police Department, correct?
It's on the impound slip. That's the only way we know. So the impound slip generated by Van Buren Police, it states the number at the top, the incident number. That's how we do our inventory.
And besides sending those weekly reports, do you correspond in any other manner with Van Buren Township?
Can you repeat that?
Absolutely. Besides the weekly reports, do you correspond in any other manner with the Van Buren Township Police Department?
With regards to this or any of them? No.
And besides the email that we talked about, that the vehicle was finally off the police hold, did you receive any other emails regarding this Chevrolet Equinox?
No.
Did you have any other phone conversations regarding the
No.
vehicle? Did you have any discussions with Officer Lucas regarding those weekly reports involving the Chevrolet Equinox?
With regards to the weekly reports, no.
So you just submit them and you usually don't hear anything back, is that accurate?
Correct. It's up to them to deem the vehicle abandoned, and they run their auctions. They submit their stuff to the newspaper. So no, we have no other interaction with them.
And the vehicle was located, the Chevrolet Equinox was located on J&T Crova, their property, correct?
Correct.
And so it would be up to you guys to determine whether or not that vehicle has been abandoned, correct?
No, that's all handled through the Van Buren Police.
And how is that?
You would have to ask their procedure. They just go by my weekly inventory.
And are you aware are you generally familiar with the Michigan Vehicle Code and the towing and storage statutes?
Some of it, sure.
And you understand you have certain obligations under those statutes?
I think the obligations were met by the Van Buren Police Department.
But do you understand that you, as a towing agency, have certain obligations to meet, correct?
And we did our obligation.
Okay, so you do understand that there are obligations, correct?
Yes.
And do you understand that one of those obligations is that you have to wait 20 days after the release of a vehicle before it can be deemed abandoned?
Say that one more time.
And one of those obligations pursuant to MCL 257.252D, subsection 5, you have to wait 20 days before you can deem the vehicle abandoned, correct?
You know what? I'm not familiar with that portion of it. The 20-day rule is if it's left here, my understanding of it, if it is here for 20 days, on the 21st day, provided that there is no hold on it, the police department has the opportunity to auction it.
And so you're not aware that after 20 days, it has to be deemed abandoned before they can proceed with the procedures to auction it?
Objection. Your
I
Honor.
don't
Ask and
think
answer.
so.
Hold on, ask and answer.
Sustained.
And would you know when the police department filed the notice with the Secretary of State?
I would be assuming, no, I'm not positive on their date.
And did you ever have any conversation with them regarding that?
No.
Did the Van Buren Police Department ever come out to examine the vehicle?
Let me go through the notes of the call. I do not believe they did come out, though. I printed every note with regards to their call, so I would know if they came in, but no.
And generally, you keep track of who comes out to look at vehicles on your lot, is that correct?
Correct.
And so if they would have came out to the property to examine it for any investigation, that would be noted, correct?
Correct.
I have nothing further.
Thank you. Any redirect, Mr. Stidham?
Yes, Your Honor, very briefly. Ms. Boken, can you tell or just clarify for the court, when you meaning the J&T Towing receives a release or to take something off hold, what does the person, individual, company, whoever have to do to get it released off a hold before they come see you?
So they would physically go into the Van Buren Police Department, present their paperwork, whether again, it's a tow company picking it up or an individual picking it up. They would pay a fee to Van Buren Police Department. Van Buren then issues them a release form. They would then physically bring that release form over to my location, pay for the vehicle and leave.
And once they pay the fee and issue the release, are you telling the court that's when the Van Buren Police Department send a notice by email to J&T Towing to release the vehicle?
Correct.
Okay. I have nothing further, Your Honor. Thank you.
Thank you. Thank you, Ms. Bokan. Mr.
Thank
Stidham, anyone?
Yes, Your Honor. The respondent would like to call Mr. John Bokan, please.
Mr. Bokan.
Yes, ma'am.
First, can you state your name for the record, sir?
John Bokan.
And Mr. Bokan, can you tell the court what's your relationship to towing?
One of the owners.
And how long have you been an owner?
44 years.
And you've towed a few cars like this 2015 Chevy Equinox in those 44 years. Is it safe to say, sir?
Yes, sir. Yes,
Okay.
sir.
And Mr. Bokan, I'm going to direct your attention to Respondent's Exhibit E, which is the towing services agreement. Can you flip to that, please?
We're pulling it up.
Thank you. You've seen that agreement before, have you not, Mr.
Yes,
Bokan?
sir. Yes, sir.
Okay. And you're familiar with its contents, correct?
Yes.
And in fact, J&T Towing is not the only towing company utilized by the Van Buren Township, isn't that correct?
Yes, sir. Yes, so there's two of us at tow.
Okay. And what are the storage rates in Van Buren Township for a vehicle like this?
$25 a day.
$25 a day. And is that for outdoor storage?
Yes.
Is there a different amount for indoor storage?
$40 a day, I believe.
$40 a day. And Mr. Bokan, those rates, did you set those rates?
No,
How
sir.
did you ride?
Van Buren Police set them.
And are those rates contained in this towing services agreement?
Yes, sir.
Okay. And when a vehicle is on hold, Mr. Bokan, does that permit J&T Towing to make alternative arrangements for the vehicle? Could you take it to a public place, for instance?
No, sir.
What do you have to do once a hold is placed on the vehicle? What do you have to do to safeguard the vehicle?
We have to secure it in our yard, which has got a masonry wall around it, 8 foot tall.
And do you have security periodically or drivers that watch the vehicles?
We got a camera system 24 hours, that's on, that's recorded.
And isn't it true that you have to safeguard the vehicle, sir, so it doesn't lose any of its evidentiary value while it's on a police
Yes,
hold?
yes, sir.
Okay. Now, with respect to the rates, you heard the petitioner say that this vehicle had been on police hold for 480 days.
Yes, sir.
And that's one of the basis that you calculated the storage, correct?
Yes, sir.
And now, Mr. Boken, does J&T Towing, doing business as JT Crova, does it tow for other municipalities or law enforcement agencies?
Yes, sir.
Does it tow for the Michigan State Police?
Yes, I have 5 police departments.
Okay. And with respect to the Michigan State Police, what are their rates for a daily storage rate outdoors?
Their rate is 20, which was set by them also.
Okay. And what about, and you also tow for the city of Romulus, correct?
Yes, sir.
And what is Romulus's rate for outdoor storage?
25 a day.
25 a day. And I neglected to ask you, sir, with respect to the Michigan State Police, do they have a indoor storage rate?
Yes, it's 40.
What? It's 40. And what about for the city of Romulus? What is their indoor storage rate?
I think it's 30.
I think it's 30. With respect to some of the other cities that you tow for, J&T tows for Sumter Township, correct?
Yes, sir.
What is its indoor and outdoor storage rate, please?
25 and 40.
25 is outdoor?
Yep, and 40 inside.
Inside. And what about do you tow for Belleville Police Department?
Yes, sir. It's the same rate, 25 and 40.
25 and 40. And do you tow for the Wayne County Sheriff?
No, sir.
No. Did you used to at one time?
Yes, years ago.
Okay. Do you know what the Wayne County Sheriff's outdoor storage rate is daily?
15 and 30.
15 and 30. What about the Metro Park Police? Do you tow for the Metro Park Police?
Yes, sir.
And does it have storage rates?
25 outside and 40 inside.
Is it safe to say, sir, that in your opinion, the outdoor storage rate of $25 here is a reasonable storage fee?
Yes, sir.
And likewise, the towing fee that was charged on this particular vehicle was also set by the agreement between J&T and Van Buren Township, correct?
Yes, sir.
And those fees allow, and you're also required, are you not, under state law to charge a $40 fee?
Yes, state fee, yes, $40.
Okay. And that fee doesn't go to you, all of it, does it, sir?
No.
A portion you have to
Yep.
remit to the Secretary of State?
25 goes to the state and we get $15 for doing it.
Okay. And as part of your obligation under the agreement to safeguard the vehicle, well, strike that. Let me ask you this. Mr. Boken, the petitioner contends that you could have stored this vehicle on a less costly basis. Is that possible?
No.
Why not?
I don't even know I would do that or how I could do that. You know, it's a contracted rate. And, you know, if you,
Operating costs.
it's operating costs, we got security.
Object to.
Well, hold on.
Okay.
Only one
I'm
person
sorry.
testified. But
What was your, wait, 1 second. What was your objection?
That the question's not posed and the striker response is non-responsive as she's not testifying currently.
it's fine, Your Honor. I'll withdraw the question and ask a more
Thank you.
precise one.
Ms. Bokan, I know you're trying to help, and I've heard you a couple of times. If you could just restrain yourself if possible.
Okay.
I understand, but thank you. Mr. Stidham.
Thank you, Your Honor. Mr. Bokan, does the contract does the towing service agreement that you signed with Van Buren Township allow you to store cars off-site, not in your
No,
storage
sir.
yard?
No, sir.
No. Could you have taken and stored this vehicle at a public storage lot because it's cheaper than $25 a day?
No, sir.
You would, had you done such an act, would that not jeopardize the evidentiary value of the vehicle?
Yes, sir.
Foundation.
And did you, Mr. Bokan?
I'm sorry.
yourself-
Did you say something?
Yeah, sorry, I don't know if it's coming through. I just object to the foundation of that question. There's no way you could possibly know what preserving of evidentiary value is on a vehicle.
Objection sustained.
Thank you, Your Honor. Mr. Bokan, would you have, did you have any discussions with anyone from the Van Buren Police concerning this particular vehicle?
No, sir.
Anyone ever come to you from Van Buren and say, Mr. Bokan, this car was on the hold when it shouldn't be or shouldn't have been? We told you that?
No.
I have no further questions, Your Honor.
Thank you. Mr. Andruski?
I just got a few questions for you. If the police requested that you moved the vehicle to an off-site storage, you would have to do that pursuant to the contract, correct?
If they wanted it done, yes, sir.
And did you have any discussions with them about moving the vehicle to longer-term storage?
I'm sorry, objection, lack of foundation, Your Honor. There's no testimony that was even asked. In fact, he just testified the opposite.
I thought that was his question. Did you have any conversation regarding that?
No, ma'am.
No, Your Honor, I believe his question. I'm sorry. I'll stand. Maybe I misheard it.
Yeah, that was my question, is that did you have any conversations with them regarding moving the vehicle? And your answer still no, Mr. Bokan?
My answer is no.
And did you ever have any discussions regarding long-term storage in regards to any vehicle with the Van Buren Township?
Never.
And you've only discussed daily rates with Van Buren Township, correct?
Yeah, that's the way it's, all the contracts are set up by a daily rate.
And do you charge any long-term rates for storage at your facility?
No.
And in this instance, did someone physically bring a release to you for this vehicle?
Yes, you're asking me?
Yes.
Or Dawn?
You.
Dawn does the office stuff. I do the guys and run the shop. So she does 99% of the office work.
I have nothing further.
Thank you. Any redirect, Mr. Stidham?
Just one, Your Honor. One question. Mr. Bokan, if the vehicle had been released, I'm asking you, as reflected in these notes by the police department, and it was never picked up, is that JT Krova's fault?
No, sir. I have no control on who picks up what.
In fact,
it's their obligation.
I have nothing further, Your Honor.
Thank you. Do you have any other witnesses, Mr. Stidham?
I do not.
Mr. Andruski, anything else?
I have no witnesses, Your Honor.
Any last remarks?
Yes, Your Honor. Looking at this case, I mean, it is clear that this vehicle was on hold unreasonably for an extended period of time when it shouldn't have. The charges against the FL driver were resolved 5 days after this incident occurred, yet this vehicle remained on hold for almost 480 days without any further investigation, which J&T Crova stated that no one ever came out to that fact. And so the hold and the reasonableness of incurring of daily charges of $25 a day is wholly unreasonable when you look at the totality of the circumstances. And as the Michigan Court of Appeals held, that the totality of the circumstances must be taken into account whether or not a more reasonable charge of long-term storage could be applied, even if this hold were actually valid at the time. Unfortunately, we do not have a representative present from the Van Buren Township Police Department to satisfy their burden of showing that they complied with the statutes. Further, as far as in regards to the timeliness of this petition, in order for that notice to be sent, a vehicle has to be deemed abandoned. And there's 3 definitions listed for abandoned vehicle. 1, that the vehicle has remained on private property without the consent of the owner. And whether it's remained on public property, which is not applicable. And then whether or not the insurance company has not acquired ownership, but that the vehicle has remained on the property for a period of not less than 60 days. Here, J&T Crova testified that they were notified that the hold was taken off on January 7th. Thus, it would only become abandoned if that vehicle remained on the private property without the consent of the owner. And pursuant to MCL 257.252D, that has to be a minimum of 20 days after that time before it can actually be deemed abandoned pursuant to the statute. Thus, the notice from the Secretary of State should not have been even issued or notified regarding that the vehicle was abandoned until it was deemed actually abandoned well after on January 27th of 2021. Thus, this petition is timely. Even if the notice states January 4th of 2021, the release was not even actually, the police hold was not actually released until 3 days after that fact. And thus the notice and the statute was not complied with as well by the Van Buren Township Police Department. And pursuant to subsection D5 again, is that the police agency shall follow the procedures set forth in section 252A if the impounded vehicle has not been redeemed. In this case, it was actually redeemed, and thus those procedures do not have to be followed pursuant to the plain language of the statute. And it's only under that scenario does the police agency have to notify that the vehicle has been abandoned, as one J&T Crova states it as such after a minimum of 20 days. Moreover, as far as the actual notice, clearly it was not sent to auto owners regarding that the vehicle had been deemed abandoned, and thus they never received notice as to that. And thus they never had notice of the Secretary of State form, and thus would have no notice as to file the hearing. Also, the notice is defective as it does not comply with several parts of the statute, most notably MCL 257.252A, subsection 6, 8, and 9, because that notice submitted by respondent does not have the procedure to redeem the vehicle. It does not have the form petition that the owner may file in person, and does not have the warning that the failure to redeem the vehicle within 20 days after the notice may result in the sale of the vehicle. Thus, the notice on its face is defective as well, and thus the notice is not sufficient in order to start the timeline of the 20-day requirement set forth in the statute, and thus the petition itself is timely. And further, Your Honor, it's undisputed that J&T maintains that the police holder was released in early January 2021. So it's impossible for it to be deemed abandoned until January 27th, 2021. Thus, filing of February 9th would be timely within the additional 20-day period. And lastly, Your Honor, whether it's J&T's responsibility to release the vehicle, they cannot release it, as they stated, until they're informed by the police. So if the police has not informed them that the vehicle has been off police hold, they're also acting unreasonably in the fact that this vehicle is just sitting out there that used to be owned by a woman who lost her life in this accident. And they did not follow the correct procedures of the statutes, and the fees were wholly unreasonable, viewing the circumstances in the totality. Thank you, Your Honor.
Thank you, Mr. Stidham.
Thank you, Your Honor. First of all, again, with respect to the timeliness of the plaintiff's petition, I'll give counsel credit for a novel argument about the defectiveness of the notice issued by the Secretary of State. But the notice is what the notice is, and the notice is dated January 4th, 2021. And here, again, counsel filed this 16 days too late, or counsel's client, rather, Your Honor, on February 9th, 2021. On its face, the petitioner did not comply with the statute. And under Noel v. Ritzer, Your Honor, 317 Mishap 506 referenced in our brief, this is a substantive term of the statute at issue of the entire abandoned vehicle scheme or statutory scheme. And as I pointed out in the brief, the case law, the word shall is mandatory under the law. And just like in Noel v. Ritzer, where the petitioner did not strictly comply with the statute, the court said that the district court and the circuit court both erred in even conducting the hearing on the matter or in granting some relief. And that's what we have here at the outset. This petition should not have, it's untimely and the court ought to dismiss it. Substantively, though, Your Honor, I think what the court heard is a pretty simplistic tale, but I want to just go back up for a second before I get into some of the factual issues to address that the petitioner's petition is that not the propriety of the tow or the removal of the vehicle, but rather simply the unreasonableness of the towing and storage fees. And here, the respondent submits to the court that clearly the respondent established that the towing fee was reasonable. It's established, as Mr. Boken said, by as a matter of contract between the Van Buren Township and J&T Towing. The petitioner offered no evidence to suggest that there was anything improper with the towing fee itself. Moreover, with respect to the daily storage rate, again, Mr. Boken identified that the $25 is established as a matter of contract between Van Buren Township and its towing agencies. And Mr. Boken identified for the court the different towing rates, which were most of his testimony seemed to be around $20 or $25 for a daily storage rate, either from the Michigan State Police or the City of Romulus or Sumter Township or the Metro Park Police, other towing or other municipalities and government agencies in the surrounding area. So clearly, the daily storage rate is it comports with the industry standards and the other governing rates in similar localities in the southeastern Michigan communities, especially in Wayne County. With respect to, and there, Your Honor, I submit that the respondent has clearly met its burden that both the towing and the storage fees were reasonable. There's been no evidence presented otherwise. Simply waltzing into this court and saying that, Your Honor, the fees are unreasonable doesn't make it so. And I believe that we've showed the court we've established both by as a matter of contract and a matter of the rates are in conformity with other rates charged in other communities for the similar work. Now, with respect to some of the facts, really, I think a lot of the facts, Your Honor, were uncontroverted. This vehicle was involved in an accident at Savage and Haggerty Roads. It was brought in on September 16th, 2019 as a result of that accident. You heard from Ms. Boken that on September 22nd of 2019, J&T received a call from the officer in Van Buren that instructed J&T to place a police hold on this vehicle, and they did so. They followed their contractual obligation and followed the instruction of the police officer and placed a hold on this call, or on this particular vehicle, the 2015 Chevy Equinox. And from there, they did receive some phone calls and inquiries about it, but as you heard Ms. Boken explain, what they tell everyone that calls is to contact the police department of Van Buren to determine whether or not the vehicle is released from hold. In fact, there certainly is more than I would submit to the court, more than circumstantial evidence that the vehicle may actually have even been released on hold on 10/16/19 in the petitioner's exhibit, where it says, no, the police stated this vehicle is released for pickup. And the significance to the respondent, Your Honor, is if that was in fact true, as you heard, J&T would not have been notified of that fact until such time as someone physically went into the Van Buren Police Department, paid the $30 fee, received that release form, and then the Van Buren would send an email to J&T to notify them that the vehicle had in fact been released, that they could release the vehicle. And if, assuming this note is correct, that the vehicle was on hold, it's the petitioner's fault that they didn't go pick up the vehicle if it was available on 10/16/19. Conversely, until that time, J&T never received any notice, as you heard from Ms. Boken, that this vehicle had ever been released until January 7th, 2021, when she identified that they had received the vehicle or received a release via email, and someone came in and redeemed the vehicle. What's interesting about the timing of it, Your Honor, is 3 days before, the Secretary of State issued its TR-52L, notifying the last titled owner that the vehicle had been abandoned and where the vehicle was held. And 3 days later, the vehicle was redeemed. So obviously, auto owners received that notice. With respect to the allegations in the petitioner's brief anyways, we certainly didn't hear any evidence to support it, but in its brief that somehow J&T Crova continually misrepresented to its agent that the vehicle was off of hold and when it was really on hold, or vice versa, I'm sorry. There simply wasn't any evidence presented. It was the argument of the parties. No evidence was presented that there was anything to the contrary. Clearly, as Ms. Boken established, J&T Crova complied with its contractual obligations. It provided the weekly inventory reports identifying each of the vehicles on hold each week from September 2019 forward. As Ms. Boken said, even though she didn't produce every single one to me to include to the court, she produced a sampling, and every single one in the sampling identified this particular vehicle as being on hold. One other thing I just wanted to point out to the court, excuse me, Your Honor, is that the reasonableness of the fees and counsel referenced the Court of Appeals opinion that perhaps they could have taken some less costly alternative to store the vehicle. But as you heard Mr. Boken testify, it simply isn't permissible under the terms of their towing storage contract, nor did the city of, or the, excuse me, the township of Van Buren authorize such action. For better or for worse, this vehicle had to remain safeguarded in the yard of J&T Towing. And the petition here, Your Honor, has simply failed to demonstrate that the fees, the towing and storage fees, were unreasonable in this instance, or that there was some defect that made the notice to improper in some extent. They simply don't want to pay the $12,000 in towing and storage fees. And here I will summarize, Your Honor, that the evidence clearly showed that J&T Towing charged a fee in conformity with its contract. Is it intrinsically reasonable? The daily storage fee, the towing fee, and as a larger matter, it did not have the unilateral ability to take the vehicle off site and store it elsewhere. It simply isn't allowed by in the towing industry or in the this particular contract. With respect to any alleged wrongdoing or failure to properly notify or misrepresent to anyone, there's simply no evidence presented to that. It's just the argument of the counsel. And so the court ought not to give that any weight. And lastly, Your Honor, again, it's the respondent's position that, and we thank the court for hearing this, but we don't even think that the respondent submits to the court that the court ought not have even been put itself through this hearing because of the untimely petition filed by the petitioner. The law is the law, as stated in Noel v. Ritzer, and the court doesn't have the authority to deviate from enforcing the 20-day filing requirement. So for all those reasons, Your Honor, we'd ask that the court find that these rates are, that the towing and storage fees are reasonable, and that the court dismiss the petition. Thank you.
Thank you. Last words?
Just a brief rebuttal, Your Honor. If we do take it as true that the vehicle was released on hold, off of the hold on 10/16 of 2019, then numerous times after the fact, J&T Crova represented when Copart tried to go pick up the vehicle that it was still on police hold. The Copart notes show that specifically on 11/11, 2019, 11/12, 2019, 11/26, 2019, 12/12, 2019, 1/14, 2020, and several other dates that are included in those notes. They still represented that it was on police hold. A driver, one of the notes say a driver named Keith tried to pick up the vehicle, and when J&T Crova would not allow it to occur because it was still on police hold. So the argument that it was potentially off police hold, I think, is more detrimental to J&T Crova than they still represented it. It was not. As far as the notice for the Secretary of State, that can only be issued if the vehicle is deemed abandoned. The statute's clear that the vehicle is only abandoned after J&T Crova says it's abandoned once it's not redeemed. And that never, the 20 days never occurred pursuant to the statute. Thus, this is timely. Also, it'd be impossible for the vehicle to be deemed abandoned when it's still on police hold for an additional 3 days. At no point would my client ever have abandoned a vehicle that they can't even have access to for 3 days. And also, Your Honor, I would just like to point out to the court that J&T Crova has put forth several documents showing in support of their burden. However, they've never submitted the actual email demonstrating that the police hold was taken off. Yes, they might have testified to it, but they have never actually presented that and have not submitted that to the court. Then also, pursuant to the terms of the contract, respondent claims that they can't change the fees. The fees are what they are. However, the contract explicitly states that the police department can change the rates based on a case-by-case basis at the sole discretion of the police department. And no discussions were had with the police department regarding the length of the police hold and whether or not they could go to a more reasonable fee due to the longevity of the hold. And that's specifically what the Court of Appeals case had stated, is that that needs to be taken into account in overall in the totality of the reasonableness. Whether the reasonableness of charging a daily rate versus a long-term charging. Per the daily rate, I will concede to the fact that if it was only charged $25 a day, that on a per day basis matter, that would be reasonable. However, it's unreasonable to continually charge a daily rate when it's there for almost a year and a half. And that's what the Court of Appeals case of Auto Club states that should be taken into account. And for those reasons, Your Honor, we respectfully request that this court find that the fees were unreasonable and issue a refund.
I want to start by thanking all of you for allowing that half-hour period for me to review the brief and response that were submitted by the petitioner and responded. They were received by the court yesterday and today. So having the opportunity to review those responses with the attachments was beneficial in this matter. I've listened to the testimony of both Dawn and John Bocon. I've reviewed the documents that both parties submitted. And at this time, the court will find pursuant to MCL 257.252 F3D that the towing and storage fees were reasonable. Petitioner's request for either a refund or a reduction in the fees is denied. And that concludes this matter.
And Your Honor, just for a clear record, is the court making any determination as whether or not the Van Buren Township met their burden, even though they did not appear for the hearing today?
They were noticed to be here and did not appear. The sole party listed as respondent in this matter is J&T Towing, doing business as Crova Towing, and the sole issue raised in the petition are the reasonableness of the fees and storage. My ruling is based on the contents of the petition and the relief requested in your brief in support of your request for refund of unreasonable storage fees.
Your Honor, does the court wish that we prepare an order or will the court?
If you would, I'd be ever so grateful. Thank you.
And Your Honor, if you would oblige, if I could just make a brief statement for the record.
Yes, sir.
I'm not trying to contest your ruling. I understand the ruling. I'm just going to state for the record that pursuant to MCL 252F subsection 1B, that the court's obligated to notify the police agency at the time of the place of the hearing so they can satisfy their burden as to the reasonableness of them complying with the statute and deeming that the vehicle was abandoned as well.
And Your Honor, if I can just put a brief rebuttal statement on the record, if the court would permit, as again, this petition, as the court duly noted, addressed solely one respondent and did not allege that Van Buren Township did anything improper. So thank you. We'll prepare an order, Your Honor. And Your Honor, can we submit that electronically back to you, or do we have to mail it to the court?
No orders have been submitted electronically through the civil department. Mr. Andruski, do you have any objection to the electronic submission of the proposed order?
No, I would just request if I could look at it real quick, Mr. Stidham, and then
sure,
submit it.
Of course.
Thank you. Thank you. Good to see you, Mr. and Mrs. Volcott. Everyone have a good afternoon.
Thank you.
Judge.
Thank you, Your Honor.
Thank you. Mary Ann, thank you so much. We're off the record.